Hello and welcome. Sorry for the brief delay, but we appreciate you taking time out of your day to join us this week. We also appreciate your continued interest in our weekly webinars, and we hope to see you at another webinar soon. As a reminder, we will be recording this webinar. We will send a follow-up email with the recording, the slide deck, as well as the HRCI or SHRM recertification codes. Additionally, we will be sending us a link to a survey which we would appreciate you completing. The results of this survey will help improve our webinars as well as allow you the option to recommend new topics that we have not yet covered or that you are interested in. We hope that you can join us next week for part 1 of our cybersecurity webinar series with Black Bottle IT. We'll be covering HR's growing role in cyber risk management. And now I'd like to introduce our speaker today, Britt Waterman, who's a senior attorney at MyHR Counsel.
Thanks, Dan. Hi, everybody. Thanks for joining us today for our MyHR Minute. Today we will be talking about marijuana laws affecting employers. There's a complex web of laws affecting employers today, and so I'm going to try to break down some of the state and federal laws and help navigate some of the legal pitfalls related to medical and recreational marijuana in the workplace. So some of the overarching issues with marijuana, so not just the moral and the ethical and the political implications of how marijuana is different, kind of the legal background, the social background. One big thing for employers is that THC, or the active ingredient in marijuana, is not the same as alcohol. So kind of up until very recently, the issue has been alcohol in the workplace, drunk driving, being impaired by alcohol. And THC reacts differently in the body. It metabolizes differently, and its impairing impact is different. So unlike the 0.08 blood alcohol level that's widely accepted as indicative as impaired, establishing a credible blood or credible level for THC impairment has been elusive. So finding out whether someone is impaired by marijuana in the workplace as to whether they used marijuana on their own time 2 weeks ago has been very elusive so far. So medical marijuana state laws. So currently 41 states and Washington, D.C. have legalized medical marijuana. The laws are very different in terms of how patients can use marijuana, what conditions are covered by medical marijuana. Some of the common conditions include epilepsy or seizure disorders, cancer, glaucoma, Crohn's disease or ulcerative colitis, post-traumatic stress disorder, multiple sclerosis, chronic or intractable pain. Those are some of the big ones that are often prescribed medical marijuana. So if you have an employee who has a condition like that, medical marijuana can be an option for an employee with those conditions. Of course, it's not limited to those conditions, and you can't ask an employee if they have a medical condition, but just for background, that's kind of what medical marijuana is commonly used to treat. So medical marijuana state laws, just to give you an example, we'll talk about Arizona. So like I said, there's 41 states and the District of Columbia, and they all have different state laws. But let's talk about Arizona just to pull one out. So Arizona has a prohibition against employer discrimination based on cardholder status. So because if you're a medical marijuana patient, your employer is prohibited against discriminating against you. So they cannot discriminate against you based on a positive drug test. You can't refuse to hire, you can't fire, you can't discipline based on a positive marijuana test if they are a registered card holder. This is waived if the employer would lose financial or licensing benefits under federal law or regulation. So it doesn't count if the employee is a DOT employee, for example. Or if you're a federal contractor or something like that, if you need to have, if you're a federal grantee, something like that would not be protected by the Arizona Medical Marijuana Act. But just an employee who is not a DOT employee is not covered under the Federal Drug-Free Workplace Act. Just a private employer in the state, that cardholder is protected by the act and cannot, an employer cannot take an adverse action based on solely on a positive marijuana test. You don't have to tolerate the use of medical marijuana on the employer's premises or during the hours the employee is on the job. So if the employee has medical marijuana on the premises or in their possession or is impaired by marijuana on the premises or during the hours of employment, employer can certainly take action in that case, discipline, terminate in that case. But just having it in their system, having a positive drug test, you cannot take adverse action against that employee if they are a registered card holder in Arizona. So let's look at the flip side. So Colorado, where medical marijuana is legal, recreational marijuana is legal in both Arizona and Colorado, but just looking at medical marijuana in Arizona and Colorado. So in Colorado, the Colorado Supreme Court ruled that the statute that so a lot of states, and we'll kind of get into this, have laws that protect employees from engaging in legal off-duty conduct outside of work. You can't penalize employees if they do legal off-duty conduct outside of work. However, the Colorado Supreme Court said that this particular statute protecting legal off-duty conduct does not cover medical marijuana use because it's still illegal under federal law. And so compliance with both state and federal law is required for the protection of the legal off-duty conduct law. So in Colorado, they said, yes, you can terminate or refuse to hire or discipline an employee with a positive marijuana test, whether they are a medical marijuana card holder or not. So there is no protection for medical marijuana card holders in Colorado, unlike Arizona. So two states, very similar, both legalized medical marijuana, both legalized recreational marijuana. Arizona says if you've got a medical marijuana card, we can't penalize you for a positive drug test. Colorado says it doesn't matter if you've got a medical marijuana card. If you test positive, we can take adverse action. So just a little example of how varied state laws can be and how important it is to know your state. And so again, this is just another slide on cardholder protection. We have, if you're wondering if you have cardholder protection in your state, certainly open a ticket. If you are a current client, if you are not a current client, please reach out to us. You can see our packages at myhrcouncil.com, or you can email us at info@myhrcouncil.com to set up a demo to learn more about the services we offer, but we can certainly provide you with information specific to your state. For the most part, as long as employees aren't bringing their medical cannabis to work, aren't working in a job where impairment might result in serious harm to others, and aren't working in a federal contractor, federal grantee job, most employers can't take this into consideration, making hiring and firing decisions in states with cardholder protection. Most states do not require Any workplace, special workplace and accommodations. Some states do require that you go through the interactive process with employees who are medical marijuana users. And we can go to the next slide. So again, marijuana and the ADA, illegal drug use, including marijuana, is not protected under the ADA if you have an employee who is not a medical marijuana card holder and they are telling you, I'm sorry, I'm addicted to marijuana, it's a disability. That is not protected under the ADA because marijuana is still illegal under federal law. Recovery from drug addiction is protected under the ADA if they are in recovery and need time off to attend treatment or support groups. That is protected under the ADA, but current illegal drug use, I can't stop using marijuana, I'm addicted, that is not a disability under the ADA. So 4 states do not have the cardholder protection, but they do require you to determine whether a reasonable accommodation can be made. So in these states, if you have an employee who tests positive and are a medical marijuana cardholder, you do have to go through the interactive process to determine whether making an exception to your drug testing policy is a reasonable accommodation. If this employee is a forklift operator, maybe not a reasonable accommodation. If this employee is someone in your office making an exception to your drug testing policy, generally probably going to be a reasonable accommodation if this employee is not impaired at work. Recreational marijuana, 19 states and the District of Columbia have legalized some form of recreational marijuana or THC containing product. Again, the laws do not require employers to allow possession, use, or intoxication at work. There are some states with legal off-duty conduct laws that do prohibit employers from taking adverse employment action against legal recreational users. So there are some states where if you drug test an employee and that employee says, sorry, last weekend I went to the dispensary and bought some legal marijuana and I used marijuana with my friends on Saturday night, and they test positive, you can't take adverse action, you can't refuse to hire, and you can't fire or discipline that employee in those states that have those legal off-duty conduct laws protecting recreational marijuana. You really don't, you don't have an option. In those cases, it's considered a legal product and employees have a right to use it. Drug testing policies do not spring drug testing on employees who you know are card holders or are following legal off-duty conduct laws. If you have no drug testing policy or a drug and alcohol policy that reserves the right to test in your handbook, any attempt to circumvent legal protections is risky. But if you decide that drug use is not going to make a difference, if you are in office and you're not safety sensitive, and if you have someone who shows that they are impaired in the office, you can terminate someone who shows up intoxicated alone, and you've got evidence that they are intoxicated just visually and based on their behavior and other factors. Different states have different requirements for drug testing policy. Make sure you have an employee handbook drafted by an employment law attorney to make sure you're in compliance with state drug testing laws. That's something an employee handbook with a compliant drug testing policy is something that's included with your Ask HR subscription. If you are a client and you haven't had us do your handbook with a compliant drug testing policy, please open a ticket so we can get that done. If you are not a client, our subscription does include an employee handbook. So please shoot us an email at info@myhrcouncil.com or go to myhrcouncil.com to find out more about that. And you should also have a before you have to determine whether someone is impaired at work, you should make a list of everything that might give you reasonable suspicion that someone may be impaired, is using, has used, possesses, or is intoxicated by marijuana at work. So make a list: odor, gait, bloodshot eyes, inability to focus, rambling speech, slurred speech, stumbling, inappropriate affect or facial expressions, inability to follow a high-level conversation appropriately, struggling with common work tasks, leaving a room, closet, bathroom, or vehicle, and leaving a strong odor of marijuana behind in the room, finding marijuana paraphernalia, witness accounts from other employees seeing the employees use, possess, have conversations in which they admit to just having used or being intoxicated. Make a list of this and have this be an internal document that you have published, that you have documented, that has been distributed to all managers, saying if we suspect someone is using marijuana or possessing marijuana at work or is impaired, this is the checklist we are going to go through, and this is how we are going to determine whether someone is impaired, and have that standard so that you are treating each employee fairly equally and consistently in determining whether someone is impaired. So don't just rely on the drug test, because if you've got cardholder protection or recreational protection, you can't rely on the drug test to see whether they're impaired at work. So have that list of possible indications of impairment at work to fall back on. And then just I realize we've reached our time here. Federal contractors, federal law does trump state law, and because marijuana is still illegal at the federal level, your drug-free workplace policy, if you are a federal contractor or a federal grantee, must ban it. You are going to lose your federal contract if you are allowing employees to test positive for marijuana, whether it is medical or recreational, even if state law allows it. DOT employees, cardholder protection, as I said, does not apply to DOT safety sensitive positions. But employees can return to work after a positive test after they complete a substance abuse program and do test negative. So thank you all for participating in today's program. I'm sorry that we ran a little bit long here, but there is so much information when it comes to marijuana, medical marijuana, recreational marijuana in the workplace. Like I said, you're going to need a drug and alcohol policy. You're going to need a drug and alcohol testing policy before this ever comes up in the workplace. You're going to want to be prepared, because you're going to want to, treat employees fairly and equally and in accordance with state law. So please go to info@myhrcouncil.com. If you are not a client, go to myhrcouncil.com to see our packages, or if you are a client, open up a ticket for any questions that you may have specific to your state law. Thank you again for being with us today, and I hope you all enjoy the rest of your day.